Good morning, everyone. Today we are discussing about one of the principle and law of torts, ubi jus, ibi remedium. As we discussed in our previous classes, there are various principles laid down under law of torts to understand its meaning and its application, how far it has been applicable in India. In definition part and also in essential part, we have to come across various elements to constitute law of torts. This is also one of the major principle ubi jus ibi remedium. What it means is that where there is a right, there is a remedy. This is the meaning of this maxim, what we call the Latin maxim, which means for every wrong, law provides a remedy. This principle contemplated in the maxim is that when a person's right is violated, the victim will have an equitable remedy under the law. The maxim also states that person whose right is being infringed has a right to enforce the infringed right through any action before a court. So that's where we can see this. The maxim, the ubiquitous remedium, is applicable in law of torts, Trust Act, Section 9 of CPC, what it says and then what it dealt about. It entitles a civil court to entertain all kinds of suits unless they are prohibited. So that's why the civil suits nothing but the person, the basic rights, what we called, and then what that has been protected under any of the law is as an equitable right to seek remedy under that law. So that's why the Specific Relief Act provides for equitable remedies like specific performance of contract, injunction, and also the declaratory suits. So that's why in our previous classes we discussed about injuria sine damnum, damnum sine injuria. Injury without legal damage, that called as an injuria sine damne. Damnum sine injuria, that has been called as a damage without any legal injury. So that's why these three cases, Marette versus Williams, and also Hashibi versus White, Bhim Singh versus State of Jammu Kashmir. We already discussed this case, but in these cases, the maxim applicable and also enlightened in this principle, enlightened this principle also in these cases. You all know Marity Williams, that has been what we called the Park case, Ashby versus White, not to cost their registered vote, Bhim Singh versus State of Jammu Kashmir, that is pertaining to the MLA not able to attend his legislature meeting. So that's why next we move on to what are the essentials that has been constituted to UBJS AB Remedium. This maxim is applicable only where the right in question is legal. So that's why this has been very much important. Whenever a person have to seek any remedy under any law, the violation of that right has been must be legal. So this is very much important. Not by hook or crook or not by illegally if he obtains any of the right, he not able to go to court of law and enforce his right. This is one of the principles. So that's why where there is a right, there is a remedy. The second important essential is a wrongful act must violate the legal right of a person, only then the cause of action may arise. This is also very much important. In ordinary suits for recovery of money, matrimonial cases, so that's why one person if he violates the rights of another person. As we see, if we borrow money and then later he declined to return back that money, the person who gives the money is got a right to sue the person who borrowed the money. So that is the case, the wrongful act must violate the legal right of a person. In any of the case, the one person has to do some of the wrongful act, but that has been violation of legal right of an individual. Then only cause of action arises and the loss incurred party or the person who suffer, he can go to the court of law to sue the person who violates his rights. This is second principle. This is second essential. In case no legal injury is done to the person, then the maximum damnum sine injuria will be applied. See, as we have seen in Ashby versus White, there's violation of legal right, but there is no losses, monetary losses. So that's why in this maxim also they pointed out that if there is no legal injury has been done to a person, then the maximum ubigus remedium is not applicable, but damnum sine injuria will be applied. So damage without any violation of legal right. In the case of Sardar Amarjit Singh Kalra versus Pramod Gupta and others, court recognized the maxim ubigus remedium as fundamental principle of law. And also it was held by the Supreme Court. It is duty of courts to protect the rights of people and to grant relief to the aggrieved party rather than denying it. See, in India also we are employed this principle in certain cases. So that's why they pointed out. This is has been a fundamental principle of law. So that's why every law, if you see whatever law enacted by the parliament, they had given itself within that only remedy has been given. For example, law of contract, if any breach of contract has been taken place, what the remedy? The damages, suit for specific performance, and also the person who violates the contract has to give compensation. These are the things. Certain rights has been violated. For that purpose, he has to give reciprocity, like what we called, he has to be reinstated in the previous position only. In one of the landmark cases, D.K. Basu versus State of West Bengal, this case is related to the cruel and human condition detained persons. D.K. Basu was the chairman of Legal Aid Services. West Bengal wrote a letter to Chief Justice of India describing the death of a person in police custody, which was published in the newspaper, the Indian Express and also the Telegraph. They published this news. Thereafter, some guidelines regarding the arrested person were issued by the Supreme Court. Court further held that the violence in police custody is violation of legal right of that person and the compensation in the form of remedy must be given in such cases. So, D.K. Basu was the state of West Bengal. In this case also, court enshrined this principle so that if any violation of legal right of a person, those who are in police custody without any trial and also without any giving any legal assistance and also without any giving information to his family members for taking bail. These are the certain circumstances the Supreme Court also in these cases and also certain high courts also apply this principle for better understanding of ubigus ab remedium. To conclude, the Latin maxim where there is a right, there is a remedy. So that's why in present context also we are applying this principle. The injured person, if it's violation of his legal right, he can claim his remedy under any of the law prevalent in that place. Without remedy, whatever right has been given is null and void. So, if the states had given, or if the person is getting any of the right, so that's why that might be right is equal to duty, likewise, right is equal to remedy to protect and also reinstate that person in his formal state. So that's the principle under law of torts remedium is applicable in certain cases, and also in India also this principle has been applicable for betterment of the injured party or the person who suffers. That is very much important.